Good morning, everyone. We're going to start in just a minute. Okay, good morning, everyone. We're going to get started. A big welcome to all of you, and thanks so much for joining ICCR and Majority Action this morning for our webinar briefing for investors on antitrust law and shareholder advocacy with Jindrik Klub and Brent Snyder, two partners and experts in antitrust and competition at the law firm of Wilson Sonsini. As more and more investors and companies recognize that the management of environmental, social, and governance risks is critical to long-term sustainability, political opponents have mobilized an extensive backlash to ESG with the broader goal of hampering corporate progress on climate change, worker rights, and other important systemic issues. This pushback is broad-based, well-organized, and has a deep pool of funding from the same network that packed the courts with right-wing judges and has more broadly been chipping away at corporate accountability. These actions include state laws in red states like Texas and Florida blocking state pension funds from investing with an ESG lens, and litigation by the likes of the National Association of Manufacturers and now ExxonMobil, challenging the authority of the Securities and Exchange Commission to oversee the shareholder proposal process. We're also seeing a spate of investigatory threats and subpoenas coming from red state attorneys general and now members of Congress falsely accusing investors of violating antitrust laws in their collaborative efforts to press companies on climate risk and other systemic issues. ICCR members and our allies have been doing collaborative shareholder engagement for decades as a vital way to communicate concerns with corporate management and boards about matters of long-term risk. While we know that this collaborative engagement with companies does not invoke the antitrust laws and that the threats by political opponents are more about stopping our progress than genuine concern about legal violations, we're nonetheless concerned that the threats will chill urgently needed action by the investor community. For this reason, we're grateful to the lawyers at Wilson Sonsini for producing the memo that they're going to discuss today. We hope that the memo and the presentation will help you understand some of the legal landscape around antitrust law and will help give some reassurance to institutional investors that our important collective work does not violate any antitrust laws and in fact even promotes competition. We'll have time for a robust Q&A at the end of the presentation, so please put questions in the Q&A box during the presentation. I also want to thank Laura De Palma from Majority Action, who helped to organize this webinar, and especially Elena Botea, who is a principal on the Corporations and Markets team at our partner organization, Omidyar Network, for her work in helping to commission this important memo. And with that, I'll turn it over to Elena. Thank you, Elena.
Thanks, Josh, and welcome everybody. I'm Elena Botea, a principal at Omidyar Network. Omidyar Network is a social change venture that has been investing and making grants to build more equitable systems since we were founded by Pierre and Pam Omidyar in 2004. As investors, we know that businesses succeed because of the skill of workers, the strength of communities, and the health of the planet. We're members of the Interfaith Center on Corporate Responsibility and supporters of Majority Action because we know that investors need to work together to build the economy of the future, an economy where both families and businesses will thrive. We're grateful to be joined by many different investors in this work, including faith-based investors who are guided by a strong sense of moral purpose, and including universal owners who know that their long-run portfolio rate of return will be determined by the health of our social and environmental systems. Now, no one investor can do this work on their own. Opponents of corporate responsibility have targeted investors who work as a part of coalitions to improve corporate conduct on environmental, social, and governance issues. We were able to commission the law firm of Wilson Sonsini to provide some high-level advice on how antitrust law generally pertains to ESG-related shareholder engagement. I'd like to thank Majority Action and ICCR for hosting today's conversation, and thank Wilson Sonsini's partners, Brent Snyder and Jindrik Klub, for sharing a summary of that analysis today. And I'll now turn it over to Brett and Jindrik.
Thank you. And Elena, thank you to Omidyar for the opportunity to work on this project, and to Majority Action and ICCR for the opportunity to be here today. We've really enjoyed our work with you that leads us here today. So just by way of a little more background, as Elena mentioned, Omidyar invited us to prepare a paper to assess the potential antitrust risks around ESG shareholder engagement. To do that, quite a wide number of stakeholders made themselves available for interviews so that we could better understand the nature and scope of the potential engagement. We've actually learned a lot during this process about the different forms that shareholder engagement can make. And one of the things we've learned is that we still have a lot to learn. But I think I can safely say today that the good news is that we believe that the mainstream of ESG shareholder engagement really should raise relatively few shareholder risks, especially if undertaken with appropriate safeguards. And that's what we want to talk to you about today. We'll begin with an overview of the relevant laws, our assessment of those laws as they potentially apply to shareholder engagement, and then we'll finish with some suggestions for compliance and best practices. Saba, could we go to the next slide, please? And to slide 3 as well. We don't need to tell all of you who have taken time out of your day to join this webinar that this is a topic of significant interest right now. And unfortunately, as Josh mentioned, controversy in certain circles. A large and diverse number of stakeholders and interest groups have found common ground around ESG risks, and with good reason. And shareholder engagement has played a really important role in highlighting these issues and pushing companies to take them into account in their operations. Importantly, large numbers of companies around the world have responded positively to this push and are increasing and taking into account a wide variety of ESG goals in their decision making. I was on an ESG panel last year at a large antitrust conference, and someone made the point that the push around issues like sustainability will inevitably produce winners and losers. And for that reason, it is perhaps not too surprising that shareholder activism about ESG has caused a backlash from industrial sectors and their backers who feel threatened by these initiatives. The antitrust laws have increasingly been used by some of these interests to push back on ESG initiatives. We've seen it from Congress, as Josh mentioned, and we've seen it from the attorneys general in certain states. This antitrust threat is having a chilling effect and is leading to high-profile withdrawals from ESG organizations like Climate Action 100. We're here today to explain and hopefully debunk some of those threats. So I'll turn it over to Jendrik right now, who can give the relevant legal overview.
Thank you, Brent. And Saba, can you please move to the next slide? So let us now just turn to a short overview of the antitrust laws that are relevant in the context of shareholder engagement. At a high level, antitrust laws prohibit anti-competitive agreements, which are agreements that unreasonably restrain trade and competition. And they also prohibit single firm conduct that monopolizes a market. Of these two forms of conduct, only the former, or the prohibition of anti-competitive agreements, is potentially relevant for shareholder engagement because of its collaborative and collective nature. There are two types of anti-competitive agreements that may violate antitrust laws: horizontal agreements between competitors and vertical agreements between suppliers and customers. Horizontal agreements that involve so-called hardcore cartel conduct, such as agreements to fix prices, share markets, or rig bids, are prohibited per se and treated as criminal conduct in the United States. Other types of horizontal agreements and vertical agreements are prohibited only if they are shown under a so-called rule of reason analysis to unreasonably restrain trade in a specific market, for example, by increasing the price of products, reducing quality or choice. What is important to note is that the prohibition applies only to agreements, regardless of their form. They can be oral, they can be, a wink and a nod. However, there must always be a meeting of minds that is evidenced by documents or by testimony of those who have reached the agreements. Parallel behavior alone of companies on the market, as long as it is the result of decisions arrived at independently, is not sufficient to demonstrate the existence of an agreement. Now turning to three specific forms of conduct which are relevant in the context of shareholder engagement. First, so-called hub-and-spoke agreements. These are agreements which have a mix of horizontal and vertical nature in them. These are agreements among competitors that are reached through a third party, typically a customer, or in the context of shareholder engagement, a shareholder advocacy group. The important point to note that these must be reached knowingly in order to create risk under the antitrust laws. This means that the competitors must be aware that they are reaching an agreement through the third party, which is essentially serving as a coordinator of that agreement. Second type of specific agreements that are relevant in the context of shareholder engagement are so-called group boycott agreements. And these can be either vertical or horizontal again. A vertical group boycott is an agreement among competitors not to deal with a common supplier or a customer. For example, an agreement among insurance companies not to insure carbon-intensive activities. A horizontal group boycott, on the other hand, is an agreement among competitors that has its purpose to exclude a non-participating competitor from the market. For example, an agreement among banks not to do business with any bank that finances carbon-intensive activities. Finally, the third type of coordinated conduct that may raise risk under the antitrust laws is the sharing of competitively sensitive information. Information such as information about future prices, output, or any other information that is confidential and gives strategic insight about a company's future market behavior. For example, sharing of information about a company's future plans to increase salaries, which, salary is a price of labor, for specific categories of workers to so-called minimum wage levels. Sharing of such type of information may create antitrust risk. The sharing of competitively sensitive information may be taken as evidence of an agreement, or in certain jurisdictions like the European Union, as a self-standing competition law violation. So with this background of the antitrust laws, let me turn over to Brent for how these principles apply to shareholder engagement.
Thanks. And Saba, you can go on to the next slide as well. Thanks. For today's discussion, we've tried to simplify this by grouping the antitrust issues around shareholder engagement into two general categories. The first category is agreements among shareholders. This type of agreement among shareholders, the first type of agreement among shareholders that could raise antitrust risks are when their agreements affect competition between them. And that's the important thing to keep in mind about the antitrust laws, is the antitrust laws are always thinking about how is competition between competitors being restrained or eliminated. So in this context, if you're reaching agreements with your shareholders in some context in which you compete with them, that can raise an antitrust issue. And one of the obvious examples where shareholders can be competitors is in the purchase and sale of shares, or perhaps if you're an asset manager or a fund manager, in attracting investors to your fund. Antitrust risk would arise if, in that context, the context in which they compete with each other, they reach agreements that restrain competition between them in some way. One example where, again, shareholders who compete in the purchase and sale of stocks might create antitrust issues is if they coordinate on divestment from specific publicly traded companies, involving the timing and conditions of the divestment, perhaps even to have some calculated effect on the stock of the company. That would be shareholders in an area in which they're supposed to compete in the purchase and sale of stock, reaching some form of agreement that restrains or manipulates that competition between them. And that would raise an antitrust risk. Likewise, asset managers who are shareholders could violate the antitrust laws by agreeing on the fees for their ESG funds. That might be considered a form of price fixing. Because again, setting fees for their funds is an area in which asset managers should be competing with each other, not collaborating with each other. In these situations, the discussions and the agreements don't actually affect the ESG activities of the company in which they hold shares, but rather they restrain the competition between those shareholders in some fashion in which they compete. Goodrich, do you want to take the next bullet?
Yes. Thank you, Brent. So the next bullet relates to agreements among shareholders in their capacity as shareholders. And this is perhaps the area which is most relevant to shareholder engagement, because these are agreements which are, to our understanding, reached in the context of shareholder engagement. In our view, the agreements, whether these are reached directly or through a shareholder advocacy group, with respect to the exercise of the shareholders' rights as shareholders in a given company or a group of companies, are unlikely to raise antitrust risk. Why? Well, because these agreements do not relate to an area where the shareholders compete. Shareholders are not competitors as far as the activity of them exercising their shareholder rights is concerned. And therefore, agreements or commitments relating to proposals for shareholder resolutions are highly unlikely to restrain trade, because again, they do not relate to trade as such. And therefore, they would not fall under the antitrust law prohibitions discussed earlier. Turning back to you, Brent, for the next area of potential concern, which is next slide, Eseba.
Thank you, Esaba. So we talked about the first category of potential risk. So now the second category of potential risk would be if shareholders facilitate agreements between competing companies. Engagement with multiple companies on a topic such as adoption of living wages is not by itself problematic. What becomes problematic is if the shareholder becomes kind of a go-between, or in the antitrust laws, a facilitator to, in antitrust terms, we call that a facilitator, to broker an agreement that restrains some form of competition between the companies. So it wouldn't be problematic for a shareholder or a group of shareholders to advocate to multiple companies to adopt a living wage. But it would be problematic if the engagement involves setting a specific wage where adoption by one company is conditioned, even implicitly, on the adoption by other companies. Companies have to make their own competitive decisions, such as the wages that they pay. And as this is one of the areas of antitrust law that sometimes catches people by surprise, is that companies are competitors for labor, just as they're competitors for customers. So they can take into account what other companies do in making independent decisions. If one company is publicly announced that they are, raising the wages of their labor, another company, even through advocacy by shareholders, can make its own independent decision to follow that conduct and do the same thing. And it probably makes good competitive sense for them to do the same thing. But they can't reach agreements with other companies that reduce or eliminate competition and independent decision-making. And shareholders can't be used as the facilitator to reach those types of agreements between companies. And as I said, that would apply to agreements where, for instance, company A, a shareholder goes to company A and says, company A, if you raise wages to $20 an hour, company B will also do so. You can go to company A and you can advocate to them to raise their wages to $20 an hour. You could do the same thing with company B, but you can't try to facilitate or broker some arrangement between them.
Another way in which agreements or collusion among companies could be facilitated by shareholders is through the sharing of competitively sensitive information. Information that is not public. So instead of brokering an agreement, the shareholder would be simply passing competitively sensitive information between company and company B. For example, in the context of informal discussions preceding the tabling of a proposal for shareholder resolution, a shareholder advocacy group may say to Bank A, while not public yet, we understand that Bank B will stop financing new coal-fired plants as from next year. However, even if this were to happen, which we understand is extremely unlikely because shareholders are not given selective access to non-public information, unilateral disclosure of this type would typically not be sufficient to create antitrust risk. For this situation to result in a meaningful antitrust risk, Bank A would have to know that the information is being shared by the shareholder advocacy group with Bank B. Then this could potentially create some risk. But again, we understand this is extremely unlikely.
Asapa, we can go to the next slide. So let's take a few minutes now and talk about some best practices to avoid antitrust risks, like the ones that we've just been discussing. With respect to agreements among shareholders, it's important to understand how you may be competing with other shareholders, and in particular, any shareholders with whom you're collaborating, whether it's in the purchase and sale of stock, or given the nature of your respective businesses, such as being asset managers. In those situations where you're collaborating or communicating with shareholders who may also be your competitors in some fashion, keep discussions focused on your engagement with the company as shareholders around issues like shareholder resolutions, proxy voting resolutions and recommendations, and keep away from topics that touch on the parameters of competition between you. Don't be talking to other shareholders about plans to divest of stock or fees that you're charging or strategies that you are taking to attract new investors to your fund. Stick to things that are core to your rights as shareholders and away from anything that is an arguable topic of competition with the shareholders that you're engaged with. So again, don't communicate or coordinate around anything to do with purchase and sales of stock or anything about the way you as asset managers are going to communicate about your customers or pricing or confidential, competitively sensitive information, CSI.
And on the second area of concern, which is the potential agreements among the companies being facilitated by shareholders, the precautions would be to stick to what we understand is the general practice of engaging around general goals rather than specific requirements. Asking for additional disclosure, performance or risk assessment, scenario planning, and so on, all of these types of sort of requests to companies, that is an area which we consider safe. On the other hand, engaging with companies either informally or formally through proposals for resolutions and asking them to adopt a specific course of conduct. For example, raise wages to a level of X or stop financing specific companies. That is more risky. Also, what is important to keep in mind is that even if it is not sufficient to show an existence of an agreement simply by competitors being in the same room, competitors getting together in meetings, it does create suspicion. And therefore, one precaution would be to avoid bringing competing companies in which you hold shares together for informal engagement or to discuss possible proposals for resolution. And finally, in the highly unlikely event that you as a shareholder would receive non-public information from a company, the key is to keep it confidential. Do not pass that information to the competitors of the company that you received it from. Saba, I think we can go to the last slide now. And by way of conclusion or the takeaways from the work that we've done so far and the paper we've prepared, our view is that despite the threats, the incendiary rhetoric, and ongoing investigations, genuine ESG shareholder engagement poses negligible antitrust risk. Whatever residual risk remains can easily be managed with reasonable and easy to follow precautions. And these can be essentially taken by sticking to mainstream engagement actions and strategies. As long as shareholders and engagement groups stick to them and do not cross the clear boundaries that we discussed earlier, the risk of an enforcement action which would be upheld by the courts is low. However, unfortunately, that does not exclude the possibility that a state AG or legislator decides to start an investigation. Because even if ultimately not resulting in anything, an investigation can still be very costly and distracting. And finally, while we try to be comprehensive in our presentation and the paper we prepared, we are doing all of this analysis in the abstract and at a general level. And if there's one thing about antitrust analysis, it is that it is always highly fact-specific. And therefore, if you are in doubt about any of your activities, please do consult qualified antitrust counsel. With this, please let us thank you for your attention, and we're happy to take questions.
Thank you so much, Brent and Goodrich. That was such an informative and instructive presentation. We have a lot of great questions in the Q&A box. I will go ahead and start with a couple of questions that came up in the Q&A box about divestment. What about investors communicating publicly on their plans for divestment? What about that? And as a signal to others? And does the fossil fuel divestment movement pose an antitrust violation if it is a unified movement? And is there a risk to shareholders in terms of divestment around fossil fuels?
Goodrich, maybe I'll take the first one. You want to take the second?
Yeah.
In terms of whether shareholders raise an antitrust risk simply by communicating publicly about their divestment, again, if you are reaching an independent decision, taking unilateral action, and ultimately want to publicize the unilateral action you're taking and why, that shouldn't raise any antitrust risk, because you are not attempting to reach an agreement. You're not collaborating with other shareholders in reaching that agreement. By making your intentions public, you do give other shareholders a basis to be more informed about their own, again, independent decision making. But the mere fact that you communicate something publicly shouldn't in and of itself raise an antitrust risk, as long as you're not communicating, coordinating, collaborating with other shareholders to do the same thing.
Yeah. And I think that is a good segue, Brent, to the coalitions, the divestment coalitions, that that does get a little closer to the line just by the collective nature of it, because it is no longer a purely independent decision that is being communicated, and it happens to be communicated in parallel with others reaching the same decision. It is, or it may appear to be, an agreement to collectively divest. I think that the specific risk would depend how, again, concrete that divestment intention is embedded in the coalition agreement. If it is in a sense of just reducing exposure or aligning activities with the net zero scenario, that is a general sort of objective which doesn't prescribe specific action as to how to get there, other than some form of reduction of exposure to certain sectors. But if there was a collective agreement to divest from specific company, that may raise some antitrust risk.
Great, thank you. Next question. If you engage with another asset manager who could be a competitor in terms of client demand in a large collaboration with a shareholder advocacy group with the same company, is that a potential antitrust risk?
Brent, do you want to take that one? I think it relates to the issues you discussed.
Sure. I think it depends entirely on the nature of the collaboration and the topics that you're speaking about. If you're in a shareholder advocacy group with other asset managers, may include other asset managers, other types of shareholders and interest groups and stakeholders, and you are collaborating on the exercise of your shareholder rights in some way, then it shouldn't raise any antitrust risks. If you were collaborating with them related to how you are going to compete for customers in some way, or price your products in some way, even if it's related to how you're going to price ESG-related products, or that the company in which you're joint shareholders, how you're going to price some product related to that company, then you are talking about a parameter of competition between you. Because as asset managers, you should be competing in the prices that you charge. You should be competing for the customers that you are trying to attract. So again, there might be times where there can be kind of gray on the edges of where one ends and the other begins. But generally speaking, if you're confining yourself to activities, collaboration on activities that are pure exercises of your shareholder rights in some way, then that should not raise any antitrust risk, even if you're engaged in those with those that you compete with for customers.
Great, thank you. Next question. How can investors tell if an antitrust activity has occurred within a trade association?
Do you want to take that one, Jindrik?
Yeah, I think that one is difficult. It's hard to tell, I think, as an investor, whether antitrust activity has taken place. Within an association, typically that then may result in some action. So it's an action that may sort of be a manifestation of some antitrust activity within an association, a change in behavior that suggests some form of collective alignment of the association members. But it is inherently very difficult to detect antitrust activity if one doesn't participate in it, because usually it is done in secret, not announced. If it is announced, then the way to find out about it is through the announcement. But I think this is a tough question, and if the enforcers knew how to detect it, that they would probably be bringing a lot more actions.
Yeah, I would say the same thing. I think that if you're an investor and trying to do your due diligence, maybe the thing that you can inquire about are kind of the practices and procedures of a particular trade association. Do they have antitrust compliance guidelines? When they have group meetings, do they have counsel present for the organization? Do they give antitrust disclaimers at the beginning of meetings about what can and cannot be discussed? You can look for some of those elements of what would be kind of effective compliance around a trade association. But I think short of sitting in the meetings themselves and getting a real sense of what's being discussed, it's hard to give you a kind of a foolproof answer. I will say by background, I was at the U.S. Department of Justice, where we prosecuted, cartels, where that I was responsible for prosecuting cartels. Jindrik had the same job at the European Competition Enforcer. And I would say that, very often there is trade association involvement in cartels, but I still believe the vast majority of trade associations operate completely ethically, legally, and with proper antitrust guidelines. And I do think that is probably due diligence that investors can do in maybe ascertaining whether, trade associations in an industry in which you're making an investment might have heightened risk in some way.
Great, thank you. There's a question around whether or not collaboration on all shareholder resolutions is the same legally speaking, and also a question around collaboration on removing directors. So maybe if you could speak to any things investors can do when voting against directors, and communicating around that would be in line with with not violating antitrust law.
I think this goes to the shareholders acting in their capacity as shareholders and exercising their rights. And even if they discuss collectively how to exercise those rights in a specific company, whether it relates to tabling resolutions that ask the company to consider GAG reductions or the removal of certain directors, from an antitrust perspective, they would be sort of identical in terms of the risks that they raise. Again, as long as that discussion relates to, shareholder collaboration with respect to one specific company. If this were to be involving multiple companies, then it starts sort of going into the area of potentially the shareholders facilitating some form of alignment among the different companies, and that's where the precautions that we mentioned, which is, do not advocate for a specific goal, specific targets, but rather general goals, would apply.
Great, thank you. There's a question about investors pre-declaring their proxy votes publicly. And I'll add a follow-up question. What steps, if any, do investors need to take when pre-declaring or pre-announcing votes in reliance on the SEC's carve-out for such pre-announcements in order to minimize antitrust risks?
I would first say, and I'll let Jindrik weigh in on this one as well. So by background, we're not securities lawyers. So in terms of any securities laws that have to be complied with, we really can't advise on that. But assuming the SEC's pre-announcement guidelines are followed, I again don't believe that pre-announcing a proxy voting position raises antitrust risk. Again, that is conduct that, to me, is the classic exercise of your rights as shareholders. And in pre-announcing, you may be wanting to influence other shareholders to kind of follow you in voting the way that you are voting. But again, that is the exercise of your shareholder rights. You're not trying to influence them in a parameter of competition between you. So announcing your proxy voting position isn't announcing that you're, and trying to galvanize people around divesting from the company, for instance, or setting, rates for the products that you charge. So to me, pre-announcement shouldn't raise any antitrust risks. Even I think coordinated pre-announcements by key shareholders shouldn't raise antitrust risks for the same reasons. You're collaborating in the exercise of your rights as shareholders, not taking action as competitors.
Completely agreed, Brenda. I think one thing that I would just say is that, whether it is a pre-announcement or the actual voting on a proposal, I think the key is to also just make sure that the proposal itself is one that does not ask for specific, prescribing specific conduct, but rather is sticking to the general goals and asking for additional disclosures and so on, or not micromanaging the management of the company. As long as the proposal is safe from that perspective, then voting or pre-announcement creates no risk.
Great, thank you. Next question, what does this mean on shareholders' ability to convene roundtables with companies, investors, civil society to discuss an issue of concern like water, access to health, access to healthy food?
Maybe let me start, and Brent, please supplement. I know we said that, anytime competitors get in the same room, it creates suspicion, but that doesn't mean that they should not be meeting. And, we certainly do not want to say that shareholders should avoid organizing the kinds of roundtables that you described. However, if one does so, it is important to make sure that no agreements are being reached in those meetings as to the areas in which the participants compete, and no competitively sensitive information is shared in those meetings. As long as these two basic principles are complied with, and frequently, and Brent talked about the association. In the associations, competitors get together all the time, and it is perfectly fine to do so and beneficial. In fact, for the industry to do so, as long as certain precautions are followed. And nowadays, as I think Brent said, many associations have some form of compliance, antitrust compliance guide, may have antitrust counsel sitting in those meetings to make sure that certain discussions, don't veer into the problematic areas. So if one organizes such a roundtable, I think it's worthwhile thinking about just alerting everybody to the things that should not be discussed. Having a short antitrust compliance statement up front, things along this kind, I think, could be helpful.
I agree with that. The only thing I might add is to some of it will depend on the makeup of the roundtable. If you have companies that really aren't competitors all sitting around the table, that's going to raise fewer antitrust risks than if you invite competitors from the same industry. which frankly may be kind of more the norm or make more sense if you're trying to drive a particular change in a particular industry. But again, I agree with Jindrik that if you're following certain precautions, same types of precautions I talked about in the context of trade associations, whatever the antitrust risk is, should be manageable.
In terms of timing of communication, let's say that multiple asset managers get out at the same time of getting out of an initiative like Climate Action 100 plus, may that be an antitrust risk?
Well, if what you're talking about is getting out of some sort of advocacy group or you know, similar association to Climate Action 100, that, you know, if it's done at the same time, well, first, if it's done independently but happens to be relatively simultaneous, that certainly doesn't raise any antitrust issues. With respect to kind of collective action and withdrawing from an organization like that, I don't think that that necessarily restrains any parameter of competition between them. They're not competing for, you know, Climate Action 100. It'd be one thing if they say, okay, we're going to stop, you know, doing business with a particular other competing business, or we're going to, you know, require a supplier to not supply one of our competitors. That is collective action that affects competition between them. But if it really is just withdrawing from a particular organization, you know, an interest group or something like that, to me, that shouldn't raise an antitrust risk, because that's not a way in which they're competing.
Great, thank you. Given increased antitrust scrutiny, how would corporate counsel recommend that investor relations change interactions with shareholder advocates?
Can I hear that one more time?
Yes. Given increased antitrust scrutiny, how would corporate counsel recommend that investor relations change interactions with shareholder advocates?
I think that the precautions, and if I understand the question correctly, investor relations, you know, of a company engaging with shareholder advocates, we don't necessarily see the need to go beyond anything other than the precautions that we've described. You know, here it would be the company engaging with its investors. There we see very little potential for antitrust risk, absent the potential sharing of competitively sensitive information and so on. So again, sticking to the precautions that we've discussed.
I agree. It's not really apparent to me that there needs to be dramatic changes in the way that I would anticipate companies handle these issues. And I agree, it would be either, you know, don't provide competitively sensitive information, or in any way allow those what should be intra-company communications to become intercompany communications.
Great. What specific rules apply for engagement services providers?
Like Glass Lewis or
ISS?
Or ISS. You know, I think that's a broad question. But again, insofar as they may, you know, relate to proxy voting recommendations, the same principles that we've discussed would apply to those. Because in that sense, those organizations could serve as potential facilitators of, you know, the anti-competitive agreements that we talked about. And again, as long as they stay away from the very clearly problematic areas that we talked about, then we don't see what other requirements they should be mindful of, at least from the antitrust perspective.
Yeah, I wouldn't add anything. I think that's exactly right.
Okay, great. Thank you. All right, so there's a couple questions about working groups. This one, what about being part of a working group on a specific topic where you share public news reports between shareholder advocacy groups? Could you speak to that?
Go ahead, Brent. Go ahead.
No, I think we were both going to say the same thing. If you're sharing publicly available information, that is not going to raise risks.
Thank you. Can you speak to the risks or absence of risk of an investor engaging a group of companies in the same industry? For example, like US electric utilities, where the investor asks all the companies to consider the same governance change, for example, to establish a net zero emissions goal.
I think there should be some caution exercised every time there is engagement with competitors, here companies in the same sector. And the key is not to become a facilitator of an agreement of, the kind that Brent described, which is going from company A and saying, well, if you do this, company B will do the same thing. That is problematic, but advocating to them separately and not sharing with them what the other companies are likely to do, what you may have found out through your engagement, that is certainly raising very little antitrust risk from my perspective.
I agree. I think the key thing is keep it unilateral. So meet individually with companies, and even if you're advocating the same position to each company, don't allow your engagement across an industry to become a means by which any sort of non-public information gets communicated between those companies. So you may have a sense of what company A may be inclined to do, but it's not publicly announced. You don't share that with the other companies in the industry. You can engage with them in the same way, but you can't say, company A, we have a feeling is going to do this based on our communications with them, so you should be doing the same thing. That could create problem. Once company A announces that they've done the thing that you're advocating that they do, then it becomes completely fine to use that as a basis for your advocacy to other companies.
Great, and I think we have time for one more question. Are there any different precautions that apply to advocacy organizations that do not own shares but that work with investors?
Not that I can think of, because whether they own or not own shares, they could find themselves in a position of being a facilitator. And as such, if they follow the precautions we discussed earlier, that's all they should be mindful of.
I agree. If they're assisting shareholders to exercise their rights as shareholders and not helping them to restrain some parameter of competition, then there shouldn't be any issues.
Thanks so much. I think we can actually do one more. Can you clarify your statement about prescriptive activity, asking for specific actions, for instance, adopting scope 3 targets, et cetera? I think that'll be our last question, if you can speak to that.
I think this one is more difficult to really be very concrete about, but Scope 3 targets, let's say asking companies to adopt Scope 3 targets, that to me still sounds like a very general goal, because a company would have to get to those Scope 3 targets somehow, but it is up to the company to decide how they get to those targets. Whether they stop doing business with, supplier ABC or customer DEF, it is up to them how they go about meeting those goals. So that is still a general goal, and the specific way to it is up to the individual companies. However, it would be problematic to say, in order to get to Scope 3 emission reduction targets, you need to divest from companies A, B, C, and D. I mean, that is being very prescriptive about specific conduct in the market, rather than setting out a general goal and leaving latitude to the company to get there.
I agree with that, because I think the way in which you achieve some of these goals can be a parameter of competition for companies. If I can achieve a goal, if I can overachieve one of these targets, or I can achieve the target in a more efficient way than Jindrek can achieve the target, that can be a parameter of competition between us. So I think simply having and setting some of these goals is fine, but you have to have the flexibility to do it according to your own kind of business judgment, and in that way, you could end up having a competitive advantage over other companies that are trying to achieve the same goal, if you find a way that's different or more efficient to do it.
Great. Well, thank you so much, both Brent and Goodrich, for your excellent presentation and really helpful answers to the questions asked today. And I want to thank every single person here for attending, participating, asking questions. We got some really great questions and generated a really great conversation today. So I so appreciate everyone's participation. And we will conclude with a short call to action and an announcement that everybody here will receive the link to the recording, as well as the copy of the slide deck. And if your questions didn't get answered, we didn't have time to get to all of them, or you want to send a follow-up meeting or schedule a meeting with Majority Action or ICCR, please let us know. And I will just drop a quick invitation to everybody here to join Majority Action's upcoming webinar, Equity in the Boardroom, Proxy Voting to Advance Racial Equity, Democracy, and a Thriving Economy for All. That's coming up on Thursday, February 29th at 2 p.m. Eastern Time. You may register using the link in the chat, and I invite Josh Zinner from ICCR to give a short announcement on his end, and we'll then close the webinar. Great. And folks can look in the chat and use the link to register to our upcoming event, and Josh Zinner will.
Sorry, I was on mute. Sorry. A big thank you to everyone here, to the lawyers, to Jindrek and Brent, to Elena, and Midjar, to Laura, and Majority Action for co-sponsoring this. Hopefully the webinar has been helpful in helping you understand the legal landscape regarding all of the antitrust threats coming from political opponents, and to give you some reassurance as you press forward in your work in this political environment. There's a lot of unanswered questions. If we can pull together additional forums to answer some of these, we will do so. Given all the challenges we're facing, collaborative engagement is more critical than ever. So we all need to mobilize in this moment. If you're not involved already in the work pushing back against the politicization of our collective work, please join us. You can contact Isaba Hawk from ICCR, isaba@iccr.org, to join up in our collective work. And again, thanks so much to all of you for joining us. Take care.